So, Renato, what's the latest in the Comey case?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm the author of the Freedom Academy Substack.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skit. Wow, Asha, just summarizing what is going on in the Comey case is really, really complicated because so much has been happening and there's so many issues with that indictment.
Yeah, this is like the Comey choose your own adventure.
I think it's almost like choose what problem, like what issue is there to challenge with this indictment. There are so many that I think we could spend an entire hour talking about each separate ground that Comey is challenging this indictment on.
Yeah, and it's basically a hot mess. And it sounds like the Justice Department kind of knows that it's a hot mess, and they're sort of scrambling to fix some stuff. But maybe we should just do a recap on what is going on.
Sure. So, I mean, first of all, I think if folks will remember that James Comey was indicted in the Eastern District of Virginia for making false statements to Congress. And you may wonder, why is he indicted in Virginia if he was testifying before Congress? And that's because these statements were made during COVID and he was making them via Zoom. It was in response to some rather ambiguous questions that were being asked by Senator Ted Cruz. And there was all sorts of reporting that the U.S. Attorney in the Eastern District of Virginia and others in that office did not think there was enough evidence to prosecute, and there were some exits for the door. Trump's team brought in Lindsey Halligan, who's never prosecuted a case before in her life, but was working representing Trump previously, and she parachuted in to become the new interim U.S. attorney in the Eastern District of Virginia. And she herself, with being the only attorney on the case, sought and obtained an indictment of James Comey for making false statements to Congress.
And to be clear, she originally sought 3 charges: 2 false statement charges, 1 obstruction charge, and the grand jury did not indict on one of the false statement counts and only returned a true bill on the others by a narrow margin. So this is just because I think this is important because there's some issues on what happened in the grand jury, and we're going to get to that in a second. And then also, as you noted, the fact that she was the only one signing this indictment is relevant to another issue that is coming up with regard to these charges. And in response, Comey has filed several motions to dismiss. So he's filed a motion to dismiss based on the face of the indictment, basically that it's not charging an actual crime, that what they've alleged is literally true, and we can talk about that. He's also wants to dismiss the charges because of selective prosecution and vindictive prosecution, and then he's also arguing that Lindsey Halligan, the U.S. attorney who signed the charges, was invalidly appointed. So all of these are happening at the same time, and there was some movement on some of this just in the last
That's
day.
right. I mean, I almost think we should take the last one first because there has been some movement on that front more recently. And I think what's relevant about it is, I mentioned that you had somebody who didn't know how to practice criminal law who is obtaining the charges in that case. So her words before the grand jury, of course, at issue there. I will also note, when I said I used the term interim, this is another one of those U.S. attorneys who has not been, there's been no, usually U.S. attorneys are appointed by the president. They are there's approval by the Senate for those nominees, and that of course did not happen here at all. And there's been some activity by the Justice Department to shore that up. And I guess, maybe I'll just say the first thing that happened, and we could talk because there's been multiple developments. One thing that happened on Halloween is the Attorney General filed a retroactive order designating Lindsey Halligan to be a special attorney, and she backdated it to September 22nd, which is literally weeks before she presented the indictments of Comey, and of course, she's also obtained the indictment against Letitia James.
Yes, and that's because of a potential procedural infirmity in the way Lindsey Halligan was, quote unquote, appointed. So the relevant statute, 28 USC section 546, has provisions that addresses vacancies in the office of the U.S. Attorney. And basically, it allows the Attorney General to appoint an interim U.S. Attorney if there's a vacancy, but that it expires after 120 days. Once it expires, the statute states that the district court for such a district may appoint a United States attorney to serve until the vacancy is filled. So what happened here? Eric Siebert was initially appointed as an interim U.S. attorney. After 120 days, that appointment by the Attorney General expired, and the district court for this district appointed him to remain on. Now, as Renato said, when Trump started tweeting about wanting these charges filed, Eric Siebert was the one who pushed back and said, no, there's nothing, there's no there. I can't bring these charges. And basically Trump got rid of him. And so the issue here is that Bondi put Halligan in his place. But the argument is that under the statute, only the replacement for Siebert would have had to have come from the district court. In other words, if you read the statute, the Attorney General only has that one-time opportunity at the start, but after that 120 days expires, until the vacancy is filled by a Senate-confirmed appointee, the district courts have to replace any vacancies thereafter. So in support of their argument, Comey's lawyers actually cite an OLC memo written by then Deputy Assistant Attorney General Samuel Alito. This is in 1986. And basically, when a vacancy exists after the 120-day period expires, and the president has either not made an appointment or the appointment has not been confirmed, it does not follow that the Attorney General may make another appointment pursuant to the statute after the expiration of the 120-day period. So in other words, the salient point here is that even Alito will have trouble finding his way out of this one, though. I mean, I'm sure he has no problem just turning on a dime if he needs to, but it does raise a question. And it seems to me that the Justice Department is actually worried, which is why they did this retroactive appointment, not a retroactive appointment as what did she call her? A special prosecutor? Special attorney. I don't know what that is, but I don't think a court is going to let that fly. Can you do that if you don't hold the authority at the time that you're bringing a charge? You can get it retroactively.
I agree. It's a little sus. But what I would say is that, a judge, even if you have this issue, doesn't have to dismiss with prejudice. So you could imagine the judge being potentially more inclined to dismiss without prejudice if there's some sort of potential genuine misunderstanding about or mistake by the government. And I would say in an ordinary case, Asha, you talk often about the presumption of regularity. In an ordinary case, I'll just tell you, if this was there had been some appointment issue with a U.S. attorney, and random drug dealer X was raising a challenge to that based on the appointment, and maybe there had been a slip up about the date, I would see this being either, denied, this motion denied, or being dismissed without prejudice, and the U.S. Attorney's Office would bring it back. You would just re-indict a week later. But obviously, this is not that circumstance. And I think you have to read all of these indictments, or excuse me, all these motions together, in that when you file motions to a judge, you're painting a picture of issues with the case. You're telling a story. And like when I file a bunch of motions to a judge in a case, when I'm challenging the Justice Department, I want to tell a story. Sometimes I file motions I think are losers because I want to use them to tell a part of the story. And I think here, part of what they're trying to tell the judge is, one way or the other, you should get rid of this case. And we're giving you a lot of different ways to get there.
I agree that they're giving a lot of different options, but I'm surprised to hear you say that even in a run-of-the-mill case that a judge would deny the particular motion that somebody was not validly appointed. I mean, that seems like a very serious issue. Like if someone actually is not vested with the authority to bring criminal charges, and it's like, yeah, okay, that was just a mistake. I mean, that's really dangerous for civil liberties, right? I mean, that means that Bondi could potentially, or any attorney general, let's leave this administration out of it, could like pull some rando off the street and be like, can you bring these charges in a court? I think what this gets to is that it's not only that she was so hurriedly appointed, but also that this would not be disadvantaging them if there were literally any other attorneys' names on these charging documents.
That's a great point. Now,
right?
That's a smart point, Asha.
I mean, if any other attorney had been willing to put their name on it, this would not be fatal. So I don't know. I think that it is a serious issue. I think it would be very hilarious if a judge dismissed it without prejudice in this case, because the statute of limitations has run.
Yeah.
So there's no way. I mean, they could say, yeah, go ahead, you can try again. Wah, wah. So there's nothing that the Justice Department could do at that point.
Yeah, it's interesting. I will say, first of all, just to address your first point, yes, I agree that it's concerning from a civil liberties perspective, but it is very hard to go up against the Justice Department when you're representing criminal defendants. I know that firsthand. Doesn't always feel fair. And the point that I'm making is, often what you're trying to do in the defense side is you're trying to show the judge, hey, there's something weird going on here. This is not your usual case. And I think they've done a fantastic job of doing that here. And it really plays into the other motions that they have. Because, you mentioned, for example, Asha, one of their other motions here is about the face of the indictment. And I have to say that is an incredibly serious issue to me. And if I was a federal judge and I was looking at these three motions in concert, I would be very focused on that. The motion that I just mentioned, the motion about whether or not there's actually are there charges that are charging a federal crime here? Because on its face, if you look at the indictment, one thing that I think you and I mentioned when we were first looking at it is that's a little sketchy about it is the words that it puts into Comey's mouth are not actually Comey's words. They're Cruz's words, Senator Ted Cruz's words. They're basically taking an interpretation of what Cruz said and they're putting that into Comey's mouth. But Comey didn't say those things. I mean, Comey just said, I stand by my prior testimony. And that's technically true, as the motion that Comey's counsel has filed. All he's really saying is that he stands by his testimony. And you could argue he's not really even answering the specific question. But then, as the motion makes clear, there's different ways of taking these long-winded questions that Ted Cruz came up with. And anybody who sat through a congressional hearing knows that because these senators don't ask crisp questions in the way that a prosecutor or a trial lawyer might.
Well, and it's also another legal sleight of hand / Jedi mind trick of trying to get something around the statute of limitations, right? Because what they're alleging on the face of the indictment is that Comey made a false statement in 2020, whatever, 4 days before before the statute of limitations expired on it when these were filed. That he made it in September 2020, as you said, responding to Ted Cruz, asking him whether he had authorized someone at the FBI to leak, something to the media. Ted Cruz was referring to Comey's previous testimony in 2017. And Comey is saying, I stand by my testimony, meaning I stand by whatever I said in 2017. So what this indictment is trying to do is basically allege that he lied in 2017. That's what they're trying to kind of bring in, bring in these events that really fall quite outside the scope of the statute of limitations. And it's interesting because the judge has actually ordered the Justice Department to produce the grand jury transcripts of what exactly Lindsey Halligan presented to the grand jury in terms of presumably what she said was the actual false statement, what she said about the timing, what she said about the law. And the Justice Department was trying to push back. And apparently the judge said, no, you have to produce these because this is really sounding like an indict first and investigate later situation. So the judge the message has come through loud and clear, to your point, that, what the defense lawyers are saying, that this is all messed up. I mean, you can tell me how unusual it is for a judge to order that at this stage, but it sounds like he wants to get into what she was doing. And if it's anything like what she did later, I mean, she, was apparently messing up these charging documents and, whatever else. I'm guessing that we're going to see another hot mess we're not going to see those transcripts, but I'm guessing that those transcripts will reveal yet another hot mess in front of a grand jury.
Yeah, really interesting issue there. And that's really, I thought, one of the most interesting and surprising things that's happened here. I will tell you, Asha, I've never seen in my career grand jury transcripts ordered to be disclosed at this stage of the proceedings. I've been practicing federal criminal law for over 20 years. So very unusual circumstance. And what it speaks to is sort of, you used the term earlier, civil liberties. And one thing that is baked into our due process jurisprudence, we have a due process clause as part of the Constitution, is the idea that an indictment is supposed to give clear notice of the crime to the defense. So the defense knows what the defendant's being charged of in a specific way. And that's important because it not only allows the defense to prepare for what the trial would look like and what defense they want to put on, make strategic decisions, and so on, but it also ensures that it commits the prosecution to a specific theory. And it basically and commits the prosecution to a specific crime. So you don't have a situation where you're basically going you don't even know what you're accused of. Like it's just sort of a non-crime or a vague crime, or you find out you think you're charged with one thing, but when you get to trial, they present proof of something else. And here with this indictment, that motion, which was really well done by the defense team, and I'll disclose, one of his lawyers, Patrick Fitzgerald, is my former boss. Who hired me as an assistant U.S. attorney many years ago. But they paint the picture of an indictment in which they genuinely don't know, or it's ambiguous on its face as to exactly what they're claiming is false about Comey's testimony. And I think they have a point there. And I think what the judge is trying to do, Asha, is look and see, what did Lindsey Halligan say to the grand jury? And I think this is what you're getting at. What was her theory about what was false? What did she explain to them? What did the jury mean here? And I think the judge is really trying to grapple with, is there some words that could be added to this indictment, like asking the government for a bill of particulars that sets forth the very specific and narrow focus of what the indictment is in response to that motion? Otherwise, the indictment has to be dismissed.
What if she actually put Ted Cruz's words in Comey's mouth in front of the grand jury?
Well, I think what the judge would have to decide is, is on the face of the indictment. So one thing that's important to remember at this stage of things, and this is why it's so hard to get the indictments dismissed at this stage, everything in the indictment is presumed to be true. It's all the allegations are
For a motion to dismiss.
yes, for the purpose of a motion to dismiss. And usually these indictments are written carefully enough that that's not an issue. You're always the prosecutor drafts it, right? So here I think what the judge is going to have to weed out or puzzle through is there a way on which you could interpret, potentially, depending on the proof here, is there an actual crime being charged here without thinking about whether the government could prove it, but just is there some sort of crime that's being charged here?
Well, and also, for a motion to dismiss, to the presumption that everything in the indictment is true, the underlying presumption is that there were actually true facts presented to the grand jury. I mean, if something is misrepresented, I assume that that's a major, misconduct issue.
That's a problem.
Like, if you lied to the grand jury, or if you were very misleading and basically duped them into voting in favor of charges based on underlying facts that are in fact not true. I mean, this to me is also part of what this judge might be getting at. I mean, if the judge is saying this sounds like indict first, investigate second, it sounds to me like there is some question about what the underlying, what was actually what the facts are, and whether that presumption that what is on the face of the indictment is true for purposes of the motion to dismiss, whether that can even be given. And this kind of gets back to what we've been talking about in a number of ways, is yet another way that a judge is questioning the presumption of regularity. I mean, this is trying to look behind the veil a little bit. And what you're telling me is that this normally does not happen.
Correct. I think there's probably three separate things that could be going on here. Okay, one is what I said. In other words, there's an indictment that is been issued here that's been returned by the grand jury,
which is confusing at best.
It's vague, and the judge is trying to figure out. Okay, the defense has raised a valid point that you could read the indictment in multiple different ways. So let's see what they told the grand jury and force the government to pick a path. Okay, so that's one thing. That's important, by the way. That's a win, even if you lose, it's a win for the defense, because then they commit the government to one theory. Okay, so that's one thing. Now, in the context of that, one thing that could come up is, I would say, making a false statement of law to the grand jury. So typically, that you do tell the grand jury, here are the elements of 1001 false statement charge. And one thing I kind of glossed over at the beginning, but you, I think, mentioned as a specific point, is that one of the two charges that survived here is actually an obstruction of official proceeding, but it's related to the same statement. So it's very similar crime, very similar, it's same facts. But, generally what you do is you read the actual jury instructions that you would read at trial to the grand jury to kind of walk through what those elements are. And if they have questions, you use the jury instructions and you instruct them on the law based on essentially pattern jury instructions that are routinely given in criminal cases. It may be that Ms. Halligan, because she's unfamiliar with criminal law, hasn't tried a case before, hasn't prosecuted a case before, she may not be familiar with it. She could have screwed that up. Okay, so that's problem one. She could have misinstructed the grand jury. And then problem two is, as you said, perhaps she gave false facts. Now, I think here there aren't a lot of facts to investigate. I mean, in other words, either he said what he said or didn't, right? Presumably there's like a video of that, right? I believe there is. I think I've seen it online of what he said and so on. There's a transcript. And then the question is, was that false, and what about it was false? And can they prove that, right? I think the latter part is where there'd be an investigation.
But if she's trying to bring in the 2017 testimony as part of that to the grand jury, I mean, that seems shady.
It's at the very least, it's.
In other words, what the underlying false statement that she was really trying to claim is from 2017, then she's trying to do an end running around the statute of limitations.
Yeah. No, I hear you on that. I will say that sometimes, so if it was done cleanly If you say, for example, if you say, oh, back in 2017, you stated that you did not kill whomever, John Doe. And then, did you in fact kill John Doe, or was your testimony in 2017 correct that you didn't kill John Doe? Whatever. And they testify, that sometimes could be enough in a certain circumstance. I think what the defense is charging here, charging, bad word term, but what the defense is arguing here and pointing out is that when there's something that's ambiguous, when there's something that could be read multiple ways, that courts have held that is not something that you could charge people with for a false statement claim, because that charge does not, it violates the protections that we have in due process in terms of giving fair notice to the defense. It's not a crime.
So we'll see what happens on that front. And then there's the other two motions that we talked about, the selective and vindictive prosecutions. The selective prosecution seems like a hard case to make for Comey, because you have to show that other similarly situated people were treated differently. And I just don't think there are similarly situated people, maybe, unless you look at I guess maybe you could look at other false statement cases. But the vindictive prosecution claim is interesting because, Comey's lawyers are pointing to all of these tweets or skeets or truthers or whatever Trump has put out, wanting Comey prosecuted. But what the Justice Department is saying is, it's not vindictive, because vindictive prosecution requires that someone is trying to go after you for exercising your legal rights. And and Trump isn't trying to go after, didn't want Comey to be prosecuted because he exercised his First Amendment rights. He legitimately believes that Comey committed a crime. He thinks he did something illegal. And he's been saying that since 2017. He's been very consistent that he thinks Comey has broken the law, and he's the president of the United States, and he's entitled to care about people who break the law and want them prosecuted. So it was kind of interesting. I was like, oh, it made that the target, the definition of vindictiveness, of vindictive prosecution, the idea that you have to kind of show some nexus between the motivation for charging and a person's exercise of their rights, did seem a little bit tenuous in terms of how Comey would be able to show.
Yeah, I'll give perhaps a hot take on this one.
Yeah, okay. Hot take.
So I would put this in a different category with the other two motions. And if you remember, I said that I often, when I am representing people who are federally indicted, I file a bunch of motions and I do it to tell a story. And some I know are winner. I hope I have a chance to win. Some I know I'm not going to win. I think Comey team knows they're going to lose this one. And the purpose of filing the motion is get this whole story out in front of the judge about how this guy was the FBI director and he's a great guy and Trump's going after him because he's criticizing Trump. That's what they wanted the judge to have in the judge's mind, while the judge is considering these other two motions, which are actually quite meritorious and motions where the defense could actually win.
Yeah, and the smoking gun tweet that they're pointing to for the vindictive prosecution claim is the one where Trump is like, time is running out. This has to be done now. And, whoever the current person is sucks or whatever. So this idea that there was someone hurriedly put in, that goes to, I think, what you're saying, that there's irregularities in these other parts of this of this prosecution.
Exactly right. So, Asha, let's talk about something really hot off the presses. The tariff oral argument in the Supreme Court today. We're recording this on November 5th, on Wednesday. And boy, it really looks like even this Supreme Court is somewhat skeptical of what Trump is doing.
Yeah, I was only getting snippets from people who were listening and either live tweeting or commenting. But the Supreme Court watchers were saying this could be 6-3 against Trump or even 7-2 against Trump. That's how skeptical the justices were about Trump's argument that he has broad authority to impose tariffs. And just as a reminder, this case that's gone up to the Supreme Court is only about a subset of tariffs, because he has issued other tariffs since these particular ones were challenged. But it is challenging the imposition of these tariffs under the International Emergency Economic Powers Act, which basically gives the president broad authority to, regulate, economic transactions and things in the event of a national emergency, if he declares a national emergency, to deal with an extraordinary threat. And basically, Trump has claimed that, at least with regard to tariffs that have been imposed, not on China and Mexico, which kind of deal with what he says is the threat for the inflow of drugs and all of that stuff, but for all these other countries that have been completely random, he says that it's because of a persistent trade deficit. And it's interesting because even though there are many statutes, that I think there's 6 or 7 statutes that explicitly mention tariffs as something that the president can do in certain situations, IEPA, which is the statute at issue here, does not mention tariffs at all. But one of the things about IEPA is that it's very, very broad, and it is not time limited, and it doesn't have any, limitations that some of these other statutes do, like in the other statutes that do give explicit power to use tariffs will say, they can only be capped at this much, or they can only go on for this long, or you have to have factual findings to support why you're doing it for a specific country. And I guess, Trump, as we have seen, probably wants more flexibility than that. But that's kind of what's raised a lot of these issues. It's just worth noting that even if these are struck down, there could be other statutes that Trump could use to impose the tariffs as well. It's just that he would have some higher bars. But in this one, I think there were some issues that came up on whether the imposition of these tariffs, which Trump has bragged about being ways that he's going to raise revenue, he's going to raise, $4 trillion, whether that is a tax that, and the power to impose taxes is under Congress, and whether that is a usurpation of Congress's power to levy taxes, and basically taxation without representation, really.
Right. Which, of course, is a big reason why we have the United States of America, right? That's why we actually declared independence from Great Britain in the first place. I will note a couple things here that I think are really interesting. One is there's a lot of business interests that are very heavily against what Trump is doing. And this is one in which Trump is trying to fight the power, so to speak, and go against other sources of elite power in the United States. And so this I think is one where, people often say Trump is, oh my God, and Trump can do everything, and we're in this authoritarian world. I mean, there are times where his coalition breaks apart. And while there's a lot of rich folks who love Trump and love that he's, doing certain things that help them, this is one in which he's creating a lot of problems for a lot of businesses in the United States. And so it shouldn't surprise everyone that there's a lot of pushback here, not only from justices, but from lots of Republicans on these tariffs. And one thing I will note is there's a lot of, I would say, core Federalist Society right-wing types who are expressing their own skepticism about this. I mean, just today, Sai Prakash, who is a right-wing originalist, who is very much in that sort of mold of the could be on the short list to get another, if there's another vacancy under Trump too, came out with an op-ed just ripping Trump's position on these tariffs, I think in part to try to influence the justices or, clerks or whatever, influence opinion on the right at this point, and basically saying Trump could tax everyone on everything, and basically mocking in his op-ed the idea of an emergency here, basically saying there are some of these nations that Trump's imposing these tariffs on for which there's trade surpluses. So he doesn't think the surplus is big enough. So he thinks that's an emergency. Like this is, basically ridiculing the policy as well as Trump's authority to do it.
Well, the stated reason itself doesn't seem to meet the definition of IEPA, that it has to be an unforeseen extraordinary threat. I mean, in the executive order where he's imposing these tariffs, he says, we have had a persistent trade deficit for decades. So that's not actually like unforeseen or extraordinary by his own admission. But as you noted, there are countries with which Trump has imposed tariffs with which we have trade surpluses, like Brazil, because he's trying to help his pal out. Bolsonaro, he's mad that their Supreme Court ruled against him, and I guess he's going to jail. And most recently, he's mad that Canada was running ads. Was it during the World Series where they basically had an ad using Reagan's voice as a voiceover talking about how terrible tariffs are to, for Americans, and, basically we shouldn't have protectionism and all this kind of stuff. And he got big mad and imposed even more tariffs on Canada. So it's just become his, Mad King kind of thing. But it is a major separation of powers thing. And it is of a piece with the way that he is trying to usurp the power of the purse, with Congress. He's trying to control the spigot and how funds are being spent. He's not using the whatever emergency funds for SNAP benefits, for example, even though he's required to. But this is now going into, their Congress's power to tax, to raise revenue. And so it will be interesting where they come out on this. One line of questioning did ask, because, one of Trump and his lawyers' arguments is, well, if you strike these down, then basically like we're in big trouble because we have to issue all these refunds. And it's like, well, who created the situation? But that question did come up. Like, what would, if these are struck down, would the government owe refunds? And I thought it was interesting that the challengers said, well, you could make a ruling that just applies prospectively. So basically, I guess countries are just SOL for all the tariffs they've paid. But, I just thought that was an interesting sort of clean solution on how to deal with that problem.
Yeah, it's not really countries. It's like these companies, right, who are paying tariffs if you're importing something, for example. Wouldn't it be? Yeah. So, but in any event, I mean, I think what this instinct that Trump has to try to solve problems via tariff is an instinct that's going to be harmful to him. And I just to take a zoom out here for a second, a lot of people ask us all the time, like, where is there hope? Where is there something hopeful to say? Because we're always talking about problems. Trump poking in the eye all of these companies and all of these, elite interests is probably not something that is good if he wants to have unfettered and unchecked power, because they do have the money to fight back. They are fighting back. There are divisions in the right-wing coalition here, and that is a good thing for people like you and I who care about having a democracy in this country where we don't have a king who is making declarations. And between that and election results last night, I think there's a lot of hope that we're going to have a democracy in the future.
Well, if you read, scholars like Ruth Ben-Ghiat and others, authoritarianism is really bad for business. I mean, and I don't mean from a PR perspective. I mean that when countries go in that direction, even though they might at the beginning be catering to, oligarchic interests or plutocratic interests or whatever, at some point you are really at their whim, right? So if what you are relying on is an economy that's based on certainty and predictability, then you're not going to get it. And I think it will be interesting to see when it comes to being pro-authoritarian or pro-corporate interests, which way this conservative court will choose.
Well, I'm just glad to see that they're not all marching in lockstep. So, Asha, before we go, you mentioned Canada and ads aired during the World Series. And during the Major League Baseball playoffs. I will note there has been a really exciting World Series and perhaps the most exciting ending ever to a World Series between a couple of teams. I don't know if you know either team that was involved in the World Series.
I do
Oh,
know.
how do you know?
You thought that I wasn't going to know who played in the World Series, but I do
You
know.
do.
Yes.
Who played in the World Series?
The Toronto Blue Jays and the Brooklyn Dodgers.
The Brooklyn Dodgers, huh? Well, unless you're going in a time machine back to the 50s, you probably mean
It's
the
not the
Los
Brooklyn
Angeles
Dodgers.
Dodgers.
Isn't it the
The
Dodgers?
Los Angeles.
Okay, it was the Dodgers. All I knew was the Dodgers. The only Dodgers I know are the Brooklyn Dodgers. Are they like extinct now?
Yeah, the Brooklyn Dodgers, they moved to Los Angeles many years ago. Mm-hmm.
Okay, so they have their roots in
Brooklyn.
It's the
That's
same
right.
team. Okay, so I got it right.
And do you know which team won?
The Dodgers.
They won.
Yeah, I know that because I was with some Canadians who were really sad.
Well, understandably, that was one of the most exciting World Series ever. The Blue Jays were leading pretty much the whole way and ended up basically giving up a run in the ninth inning and in just devastating fashion, just inches. It's like a game of inches. They talk about that. It was like literally inches in terms of where that the foot was of the catcher in relation to the plate, and then ended up losing in extra innings to a home run. So and then a double play that they had a chance to tie it or win it again, and then they had a double play at the very end. So very disappointing. I will say I felt bad for our Canadian friends who were devastated because that was exciting. And, the Dodgers had won last year, so it would have been nice for Toronto to have their crack at the title as well.
Yeah. I should have, I have watched the World Series before, like the final game. There was one year, it was a Kansas team that won.
The Royals did win a number of years ago.
It was like a really exciting ending as well, as I recall.
So there you go. Well, I will say there's a lot of inequity in baseball where you can spend a lot more if you're a rich team. And the Dodgers had a massive payroll. So there's a lot of discussions around that. I think a lot of people were cheering for the Blue Jays because they were underdogs. Unfortunately, this time the underdog didn't win.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.